Thank you so much for joining us today. I'm Amy Burnham, Sales Team Leader with Western Title and Escrow. I'm joined by a couple of familiar faces from our sales team, Hannah Williams and Carlene Soriano. So our original plan today was to play for you our recorded webinar from last week on landlord-tenant law, but in true 2020 fashion, things changed last minute. So we are very, very fortunate to have our speaker, Craig Russillo, able to join us again for a short time this morning to address the changes that occurred on Monday, which is Governor Brown's extension of the residential eviction moratorium. So without further ado, I'm sorry. As soon as Craig has to sign off, we will go ahead and play the full webinar from last week, the recording. So if you're here for CE credit, just make sure that you're logged on for a full hour, including our time with Craig today, in order for us to be able to issue your certificate. Okay, now take it away, Craig.
Oh, good morning, thanks. Yeah, as noted, the presentation we did last week is sort of rendered, a large portion of it is sort of rendered moot by the governor's executive order 2056. I'm just going to put that on the screen. We can walk through it. The executive order, you can find it online. It's executive order 2056. If you just go to the Governor Brown's website, executive orders, as I'm scrolling through it, this top part here is just some justification for it. The real sort of meat of it comes at page 3. And so might be a little bit weird because you're going to get a lot of the information when you hear the rebroadcast. And so a lot of the stuff we're talking about here may not make a ton of sense, but what this executive order does, so under the old 4213, which was the subject of our previous presentation, was the moratorium, and that was under Oregon state law passed by both chambers and then signed by the governor. And that had an eviction moratorium that ended tomorrow, or today actually, ended today. And then in that, in that presentation, we talked about what can you do after the moratorium, and it talks about the 6-month repayment period, whatnot. So what this executive order has done is it's an executive order. It's not legislation. So one could argue the enforceability of it, and someone may at some point, but the governor has extended the moratorium period, or actually put in a new moratorium period from September 30 to the end of the year. And it really tracks the, Section 1A is the moratorium period. You're going to see that language. I think it's actually emergency period in 4213. That's the same language they're using, or it's similar language. The non-payment that you're seeing in there on Section 1B is almost identical to that in 4213. It basically means that you can't, anything that comes due, rent, utilities, whatnot, all those things are there. You can't evict someone for the non-payment of that. The termination without cause, basically what this means is that you can't terminate someone without cause to the extent you could, which of course, as landlords know, became very difficult after the passage of Oregon's rent control. No cause evictions became difficult, almost impossible after the first year of tenancy, unless you had certain qualifying circumstances. And in in this executive order, as well as 4213, if you see down here, termination notice without cause, it references a bunch of terminations. These also include, for example, terminating, your tenancy because you intend to demolish the unit. So these are the permitted no-cause terminations after the first year of tenancy. Your limited landlord can terminate the tenancy, of course, for no cause. I mean, if a tenant breaches a lease, you have different remedies there. But for no cause, you can terminate the lease if the landlord was going to demolish the premises and use it other than residential use. The landlord intended to undertake repairs and whatnot. Those are prohibited. What's interesting is that under 427 5C and D, those are not included in this executive order, and those are the provisions that allow a landlord to terminate a lease if if you're having an immediate family move in, or you've sold it to someone else who's going to use it as their primary residence. So it's important, if you're thinking about terminating the lease for those reasons, that there's carve outs there. So you got to really carefully look at that. But in essentially 2056, it has this moratorium. A lot of this language tracks 4213. So what I'm saying in the presentation that you're going to hear, it is very useful for this. You can't deliver a notice of termination, you can't threaten it, you can't continue to FED, whatnot. So whereas before in that presentation I said, well, beginning October 1, they have to pay rent. They don't really have to pay rent now. They don't, I mean, you can't do anything. They can pay rent, but you can't do anything if they don't. So the big difference between the Executive Order 2056 and House Bill 4213 is that the latter has a repayment grace period. And note, in my presentation, I say that the grace period is till May 31. It's actually till March 31. So it's a little bit different there. So any event, they have this grace period to repay the rent. They have to give notice of that right. If they don't give notice of that right, then there's a question of what you can do. That the tenant is susceptible to a small penalty of half a month's rent if they don't give the landlord notice of their intention to avail themselves of the grace period. But I don't think that if they don't avail themselves, you can evict them. I think that's an open question. So you just have to assume that they have 6 months grace period to repay the loan, or the past due rent that occurred during the emergency period under 4213, which of course ends today. So don't conflate the emergency period under 4213 with the what they're calling here is the eviction moratorium period, because the eviction moratorium period, there's no grace period to repay the rent. So come January 1, absent anything else, tenant has to pay rent immediately of all that rent that accrued during the eviction moratorium period. They don't need to repay the rent that accrued during the emergency period. Yes, if your head's spinning, it probably should be. Another thing that may not be applicable is the CDC's order that that came out prohibiting evictions. That went from September 4, I think, or 2 to the end of the year. In the presentation, I think it applied. I said it applied because Oregon didn't have a moratorium in place during that period. But I think now, because Oregon does have a moratorium, I think that it supplants or replaces the CDC order. So you need to look at Executive Order 2056 instead of the CDC order. The takeaway, though, is that if your tenant breaches a lease in anything other than a non-payment, you can evict the tenant. You just have to give them the regular notices and whatnot. So the rest of the information in the presentation still applies, specifically with regard to the repayment of the accrued rent during the emergency period, and the notice that goes out under both. Under the 4213, there's specific requirements for the post emergency period notice that you have to send out. Under Executive Order 2056, if you send out a notice, say, hey, rent's due, you can do that, but you have to tell them that there's an eviction moratorium in place. It's in section 3. If a landlord delivers a notice under section 4 of the House Bill 4213, what they're talking about, or delivers a notice under section 3.7, it has to state that the eviction for non-payment is not allowed before December 31, 2020. Okay, so that's the requirement. So when you're sending out these notices, just be careful. And of course, just like 4213, if you get rent during this period, the eviction moratorium period, you have to apply it first to rent during the period, utilities, late charges, and other fees. So, you know, you're going to have to list, you know, the presentation is helpful for a lot of information, but House Bill 2056 has rendered a lot of it sort of not completely accurate. So you're going to have to do a little back and forth on this to make sure you're doing exactly right. So that's my update. The statute is, or the ordinance is not very long. It's, I think, like 4 pages. So I suggest you read it and in connection with the other stuff. And if you have questions, you can certainly reach out, you know, and send general questions. I mean, we can respond generally on issues about your how the interplay between these statutes. So that's what I got for today.
Perfect. Thank you so much, Craig. Really appreciate it.
Yeah. Okay. Thanks, guys.
All right. See you soon. Okay. So as he mentioned, feel free to enter questions in the Q&A box. We'll send him an email with any of those, and then basically he'll decide which ones he feels most comfortable answering, since he is an attorney that's giving legal advice. So, okay, I'm going to go ahead and share my screen now, and we will play the webinar from last week.
My name is Craig Rosillo. I'm a shareholder at Schwab. I've been working for the firm for about 23 years. Most of my work focuses on real property, commercial litigation. I actually lead our litigation department. Much of my experience has been involved in commercial lease disputes, although I've handled a fair number of residential disputes in my time. So kind of jumping right into this, we have 2 really significant pieces of, not legislation, but laws / orders governing the landlord-tenant arena in the COVID times. So we have House Bill 4213 and then House Bill 4204. That's the House Bill 4204, which I'm going to touch at the very end, is the House bill allowing for certain borrowers to avoid making loan payments. And I'm going to bring this up at the very end, because if you're a landlord and you owe money to your lender and your tenants aren't paying, you may want to avail yourselves of the payment deferrals under House Bill 4204. Then we also have the September 1, 2020 CDC order, which is what's being called as the CDC eviction moratorium. These House Bill 4213 and the CDC order are really the laws that we're going to be talking about today in detail, and they are the ones that impact the landlord-tenant relationship, especially at the residential level. So we'll talk about House Bill 4213 first, and then we'll get into the CDC order, and then finish up with House Bill 4204. So 4213, this is the text of it, the first page of the text of it. You can Google it and read it. It's not very long. If you just put in Oregon House Bill 4213, you'll get a copy of it, and you can read it if you want to from, I think it's like maybe 3 or 4 pages. But there are some provisions in here which are important to note. The first is what's called the emergency period. That's the period beginning on April 1, 2020 and ending on September 30, 2020. Interestingly, House Bill 4204 had the same emergency period, but that period was extended by the governor to the end of the year. House Bill 4213 doesn't have that provision, so it expires at the end of September. Another term we need to define is the non-payment. It means the non-payment of a payment that becomes due during the emergency period to a landlord, including a payment of rent, late charges, utility or service charges, or any other charges or fees described in the rental agreement. 2 things I want you to notice: rent that becomes due during the emergency period. Okay, so this technically doesn't cover rent that accrued before the emergency period, if it became due before the emergency period. However, we'll talk about what you could do with regard to rent obligation that is unpaid prior to the emergency period and what you can do regarding that. And then non-payment balance, and that is included in, we'll talk about that, that's a defined term, includes all or a part of the net total amount of all items of non-payment of rent. And keep important that the non-payment balance is during the emergency period. So when you're looking at this, you need to figure out, okay, from April 1, what's owed? That's the amount of rent that is entitled to, is protected in the sense of it doesn't need to be paid, and for which the tenant has the 6-month grace period. So if you have rent that accrued prior to that, it doesn't get lumped into the non-payment balance between these two periods. Okay, so that's important to note. Even though the House Bill 4213 eviction moratorium is ending on the end of this month, how you process the payment of rent, how you deal with your tenant after that is very important. Obviously, there are prohibitions now, we'll talk about that, but there are also prohibitions after the emergency period expires, which, you know, govern what the landlords can do. And really this presentation, as I indicated from the title, is, you know, landlords in the age of COVID, sort of a play on the love in the age of cholera. But, you know, this equally applies to tenants. So it's not necessarily geared towards or providing only landlord information, it's providing all the information relevant. So, so House Bill 4213 applies to both residential and commercial tenancies. That is a departure from the CDC order, which only applies to residences. So ORS Chapter 90, otherwise referred to as the Oregon Landlord-Tenant Act, and then ORS Chapter 91, which is just tenancies. For a tenancy not covered by 90 is a tenancy covered under ORS Chapter 91. Again, I'm not suggesting that you paw through the Landlord-Tenant Act. It's complicated. It's full of tons of traps for the unwary. But just wanted to let you know that this applies to both. So if you have commercial tenants, they can avail themselves of the benefits. And most of the provisions are essentially identical. So the first thing we want to talk about is, what does House Bill 4213 prohibit? Those prohibitions both are during the emergency period and afterwards. So the first thing is, you can't terminate someone for non-payment balance. In other words, so if they owe money for rent that accrues during the emergency period, you can't, and not paid, you can't terminate them. It doesn't cover rent technically on that accrues before the emergency period. But you'll see later on as we go on that you can't evict someone for rent that accrued beforehand. So number one, can't terminate them because they don't pay. Of course, this is contrary to the Oregon law, which typically allows a landlord to terminate on 72 hours notice. So that's the first one. Second one, you can't initiate or continue a FED of a dwelling unit based on a notice of termination for non-payment delivered on or after April 1 of 2020. So if the rent accrued before April 1, or but the notice of termination is sent afterwards, you can't proceed with an FED. And you can't, so the really only way you could proceed with an FED would be if you terminate the tenancy before April 1. So if you didn't terminate the tenancy before April 1, then you're sort of stuck in this situation here. Even if, you know, if rent's being paid, it doesn't really matter. There's a prohibition on that. Again, so it covers the pre-emergency period rent. Again, if you've terminated the tenancy March 28th and you haven't filed an FED for some reason or other, then you might be able to under 4213. But I assume that if someone hasn't, if you've terminated in March and someone hasn't paid, that you've long since done that. Although with the moratoriums that came up, perhaps not. So, you know, each of these situations you're going to have to look at carefully But if you didn't submit a notice of termination, then I think you are prohibited from doing that until the end of the emergency period. But important to note is the rent that accrues before the emergency period is that rent is not available under the grace period. So upon the end of the emergency period, September 30, on October 1, if they owed money, let's say in March, you could ostensibly say, hey, you got to pay this now. You do not have the right to hit 6 months to pay it back. So we'll talk about that as we go under the grace period here. But continuing on with landlord prohibitions, you can't take any action that would interfere with a tenant's possession or use of the dwelling based on non-payment. This one's a little bit of a head scratcher because you know, we can't do lockouts in residentials. You can in commercial maybe, but not in residentials. So, you know, this may be like, you know, don't look at your tenant weird. That's kind of tongue in cheek, but I really don't know what that means. But the takeaway here is you can't take any adverse action to your tenant because they're not paying rent. And that could be everything from, you know, putting up signs that they're not paying. You know, you're not going to shut off utilities because, again, that's another violation of the Landlord-Tenant Act, especially when you're dealing with residential tenants not providing essential services as eviction. So, you know, the prohibition is you can't take any action that would interfere with their right to possession or use of the dwelling. So whatever that may be, you can't take it with regard to the tenant for non-payment or non-payment balance, which includes rent, utilities, late charges, whatever. You can't assess a late fee of any other penalty on tenant's non-payment balance. So as we'll talk about going forward, the tenant is accruing this non-payment balance from April 1. Let's assume the tenant hasn't paid since April 1, April, May, June, July, August. They're accruing this balance, right? You can't charge a late penalty, and also you can't charge interest. So what you're effectively doing here is you are effectively giving the tenant a loan, interest-free loan, not giving, the tenant is getting an interest-free loan under 4213 for the emergency period. They have to pay it back within 6 months. And so it's effectively almost it could be up to a year interest-free loan depending on when rent's not paid. So takeaway here is you can't tack on any late fees or any charges for the tenant availing themselves of the rights under 4213. Moving on to prohibitions, you can't report a tenant's non-payment balance as a delinquency to any consumer credit reporting agency. So the consumer credit reporting agencies, the main ones, of course, Equifax, Experian, TransUnion. If they're not paying, you can't report them as not paying. I would take no action with regard to the non-payment. I would not notify anyone. I mean, during this emergency period, it's basically a freebie for tenants. And they can't be punished in any way. I mean, that's just fair or not fair. That's just the statute. So can't take any action, can't report them to the credit bureaus for non-payment. Now, if they go into, you know, if let me back up, if they haven't paid in February and March, then you might be able to, but you know, you're really sort of putting yourself at risk here if you take some aggressive action against your tenant. You know, there are situations where that might be necessary, but you know, just keep in mind that if you're trying to take some action that occurred prior to the emergency period, during the emergency period, it's going to be really examined carefully. So unlike the CDC counterpart order, the tenant doesn't need to tell the landlord or give notice of anything to trigger application of the statute. So if the tenant's not paying, it doesn't matter if they say, I'm not paying because of COVID, or I just don't want to pay. There is no sort of threshold requirement that tenants say, well, I'm not paying. Now, it's important to remember that the rent is not forgiven, it's just deferred. So the tenant doesn't need to give the landlord notice like, I'm not paying my rent because of COVID. And again, when we conclude, we'll talk about House Bill 4204, where there is a requirement for commercial, residential and commercial borrowers to provide some notice to the lender. Here in this tenant, in House Bill 4213, the tenant need not provide any notice. So if you stop getting rent checks, or if you have stopped, then they're under the protection of 4213. So the prohibition also prevents no-cause terminations. Now, for those of you who are, have multiple properties, you are probably aware of the Oregon's sort of rent control statute that came out, I think, a couple of years ago. We actually did a presentation on this in Bend, a couple actually. So that statute essentially says, look, if you have a tenant in there for more than 12 months, you can't no cause evict them, except for very limited circumstances. And that's sort of beyond the scope of this presentation. But just know that during this emergency period, there's no cause termination. So if you have a tenant that was in there before, inside 12 months, and you could no cause them, you can't no cause them now. If they were out there after 12 months, you're certainly limited. And then there are some carve outs for what you can do. And, when you're dealing with this and you look at the statute, but essentially there are no cause terminations. What's also important is the first year of occupancy under the statute. Once a tenant is after the first year of occupancy, they have these protections on the no cause. What this statute does is it basically says, look, that first year of occupancy is extended 30 days from the end of the emergency period. Okay, so whatever provisions within the statute that allowed you to take some action at the end of the first year of occupancy, that's going to be extended to the end of the emergency period. So that's obviously important to keep in mind if you're contemplating a no cause eviction. And again, what we're talking about here today mostly is tenants not paying rent, and how do you deal with that both during the emergency period and afterwards. So you are not without remedies here for evictions, both under the House Bill 4213 and also under the CDC order. There are permissible evictions. Any non-payment cause-based termination of the lease. So what does that mean? So it can't be payment of anything. So it could be damage to property. It could be, there are a number of breaches under the lease. Of course, some of them require notice and opportunity to cure. One of them could be, you have an animal there that you're not entitled to. It could be that, you have multiple guests there. It could be that you are not occupying it anymore. So just know that 4213 is sweeping, but it doesn't limit your ability to evict the tenant under a non-payment cause base. And of course, if you're going to terminate a lease for cause, you have to look at your lease and look at the Landlord-Tenant Act to make sure that you're sending out the right notices. And again, that's sort of beyond the scope of this, but keep in mind that as of January this year, the notice provision has changed, requiring landlords to give tenants notice of available sort of veteran benefits or resources available. So anyways, if you're a property manager, or if you have a property management company like Cobalt 8, are well versed in these changes and can assist you with that. So know that you do have possibilities here. Also important to note, as I stated before, rent is not forgiven. The rent continues to accrue on the lease during the emergency period, and the tenant is obligated to pay it. I put in there eventually. So, it's a kind of a rub. If you're expecting that rent payment to cover your mortgage, then you're going to be in, you're going to have a timing issue here. But you should be entitled to it. You should get it back. You are entitled to it. You should get it back. Of course, we all know the situation where tenants may be racked up, it's like 7 months of rent. And then of course, maybe they barely had any money to begin with. And what are the chances you actually seeing that? So if they move out or they don't pay, then of course we can talk about your remedies there. both with regard to removing them from the premises and also collecting it down the road. But that's no different than any regular landlord-tenant situation with the tenant not paying rent. If you get payments during the emergency period, it's important, the statute sets forth how you are to apply that, notwithstanding your lease. So the first thing you do is rent for the current rental period, okay? So you can't take your payment and be like, well, I'm paying previous month's rent. You know, you have to pay the rental, or I'm paying January's rent. You know, you have to pay it during the current rental period. Secondly, utility or service charges. 3, late rent payment charges, and 4, fees under 90 ORS 9302. And that statute contains a litany of fees that you can charge, you know, dog fees, you know, all these different types of fees. They're too voluminous to put in here, but no, the takeaway here is the money you're getting during the emergency period, you don't apply it the way you think or under your lease, you apply it under the statute. That's the way that you have to apply it in that order. So what can a landlord do? Not a lot, but you can do something. Before the emergency period expires, the landlord can give the tenant written notice that the tenant still owes rent. You know, some tenants may think that, well, I don't have to pay rent during this, or I don't owe it ever, it's forgiven. It's not forgiven. If you do send that notice out, you have to include a statement that eviction is prohibited until after September 30, 2020. Okay, so this is a pre-expiration emergency period notice. If you don't send that notice out, you're violating the statute, and the statute does allow for penalties to a tenant can bring. And of course, if you try to evict and the tenant throws up that you didn't comply with this law, it's a possible defense to the eviction. So anyways, notice that if you want to remind your tenants, hey, you still owe the rent, you can do that, but you need to put in that the evictions are effectively, well, they are banned until after September. So the emergency period ends. So in a week or so, a couple weeks, the emergency period expands. What do? What's the next step? So you can send after September 30, you can send a written notice. The statute sets forth what that written notice has to include, or may include. Well, has to include, rather. You don't have to send the notice, but if you do send the notice, it needs to include these things. The date the emergency period ended. You can demand payment within 14 days. So even though there's a 6-month grace period, the statute allows the landlord to say, hey, you owe me this money, can you pay it in 14 days? There's a big but there, but just know that you don't have to wait until the end, the demand, to say, hey, well, pay me by this date. You can say, pay me in 14 days. It can't be less than 14 days. And remember, when you're sending these notices out, keep in mind when you're sending them. It's not very intuitive that how the time is calculated. If you're just strictly mailing something, you're going to add 3 days. If you're posting and mailing, you have to, under your lease, you have to have a reciprocal posted mail under your lease. So, my sort of standard practice when I have these deadlines, and I'm not dealing with counsel where I know exactly how to serve it, is I always just build in extra time. So give them 21 days or whatever, 30 days. You can give more time, but if you're cutting it short, then you're going to have a real problem if the tenant resists. You have to tell them that rent and other payments that come due after the emergency period must be timely paid. So if October rent comes up and they don't have it, you can send a 72-hour notice on that rent. Even though they had the protections in the emergency period, that protection ends for non-payment. Beginning October, rent has to be paid, unless, of course, you choose to you don't want to accept it or work with the tenant, but the tenant does not have the right to not pay rent after September. The non-payment balance accrued must be paid. That's sort of same as number 2. that there's no late charge on the non-payment balance, and you have to tell the tenant that they're entitled to a 6-month grace period to repay the balance. So that notice, that post-emergency period notice, has to tell them, hey, you do have a grace period here. So you can't sort of just say, pay me, and then if they're wise enough to know this, then they can avail themselves of it. You have to tell them about it. You can tell them, hey, let's do an alternate payment plan. You can tell them that, but it has to be voluntary. So you could say, hey, you have 6 months. I'd like you to pay me in 3. Here's how I'm proposing to do it. What do you think? If they're fine with it, they're fine with it. And maybe some people just needed a month or 2, and they don't need the full 6 months. You can do that, but you can't make it mandatory. You can't threaten, like, if you don't do this, I'm going to kick you out. So you can, give them a short or work out a negotiated deal. Maybe you say to them, hey, if you pay in 3 months, I'll knock 1 month off or something like that. You can do those things. The statute doesn't prohibit it. So there's some leeway there. So when does a tenant have to give notice? So again, the tenant doesn't need to give notice when in order to avail itself of the rent deferrals, okay, or even the 6 month period to pay it back. If the landlord makes demand for payment, the tenant has to provide notice of its intent to use the grace period to pay the non-payment balance. So you send the demand out, it contains all the things that it contains. Tenant then, within the time period set forth in that letter, can't be less than 14 days, tenant needs to tell you that they want to use the grace period. It must be actual notice, and that's defined in the statute, or by electronic means. Electronic means fax, email, text, social media, I don't think, but certainly email and I think text as well. So that's the way that the tenant has to explain it. Now, it's important to know, and in those landlords out there, that actual notice is not the same as written notice. Written notice under the Landlord-Tenant Act is a defined term, and it says what it needs to contain or whatever. Actual notice is different, and the must be given by a tenant, must be given by the date and landlord's demand not less than 14 days. So what is actual notice? This is the statute, ORS 9150, service delivery of actual notice. When this chapter requires actual notice, service or delivery of that notice shall be executed by one or more of the following methods, and it goes through. A couple things to point out here. Verbal notice, okay? That's a phone call. You're driving by the car like, hey, I'm gonna use my 6 month grace period. That ain't much that's not a high burden. So, it sort of behooves each landlord here to, talk to the client, talk to your tenants, say, hey, I sent this letter out, figure out if they're gonna avail themselves. Because, if they don't, and you try to go after them for that, the remedy for not giving you notice, they may say, oh, no, I told you, I gave you verbal notice on your telephone answering device or whatnot. And again, remember, the electronic means could mean, oh, I texted you, I sent you an email, whatnot. Also, there's this, any other method reasonably calculated to achieve actual receipt of notice as agreed to and described in a written rental agreement. So in this situation, if you're posting up, the posting might be fine. It's not fine for written notice, but it might be fine for actual notice. So point is, they have to tell you that they want to avail themselves of the 6 months, and they have to give you actual notice of that. So what happens if the tenant does not give notice they intend to use the grace period? So this is the situation where you've sent out the demand. Tenant says, you just hear nothing from the tenant. Okay, so again, the tenant only needs to give you notice if you demand. If you don't demand, the tenant has the 6 months to repay the accrued rent and whatever fees without penalty. But if the landlord makes demand, then that time period, the tenant has within that time period has to get back to the landlord. If they don't, you can't evict them for that non-payment balance. So really, if they don't pay, so if they accrued a non-payment balance, they really have until the end of May or May, whatever it may be, the 6 months to pay that, even if they don't give you notice. The thing is, here's what you can do. So the penalty for the tenant is the landlord's entitled to damages for up to 50% of 1 month's rent following the grace period. So, you know, what is that? I mean, it ain't much, right? It's, they don't avail themselves of it, then, you know, you can sue them for half of 1 month's rent following the grace period. So those are your remedies, right? What happens if the landlord violates the statute, though? This is also the big one, right? So it's a defense to eviction plus up to 3 months rent plus actual damages. And one thing I didn't include there is plus attorney fees. So you need to be very careful here with this statute. And I think that the moral of the story is you got to be very careful here. It's, you know, the Landlord-Tenant Act is very complicated, number one, and it's even more complicated because of 4213 and its interplay. So, you know, you don't talk to an attorney, but talk, you know, if you're representing landlords or you're a landlord, then it's important that you know, kind of figure out, okay, can I do this or not? My recommendation is, you know, be as conservative as you can stomach, because that's probably going to give you the best chance. So, you know, when the tenant has accrued this balance, the tenant, again, after the emergency period, tenant must pay rent as due under the lease, okay? October, November, December. They can't continue to accrue that. You can't evict them for not paying the non-payment balance until end of May. May is the end of the 6 month period. If they don't pay, then you can treat that as a non-payment of rent. And the statute is kind of gracious that the acceptance of rent doesn't restate doesn't waive your right to collect that rent or waive your right to default them, accepting partial rent. So, you know, if you come to at the end of the grace period and they haven't paid any of it back, then you're going to send a notice to them to say, hey, you haven't paid your rent, you owe this much, and then you do your 72-hour notice and go forward. So that's the 4213 in kind of a nutshell. You know, there's several moving parts and how they interplay together, but it is ending the prohibitions in terms of evicting a tenant are ending at the end of this month, but of course the statute still continues on. So the second piece of this, and remember we're talking about the CDC, is the CDC September 1 eviction moratorium. Yeah, this was sort of a big deal. What's interesting is the CDC, you know, is an agency of the government, and it promulgated this. It's not even a rule; it's just an order. And there are all, you know, some questions about whether that's appropriate or not. But fact of the matter is, it is an order from the CDC. If you want a little bit of light reading, you know, and you like to peruse the Federal Register, it's at volume 85, number 173. You can look at it. There's a ton of stuff on the internet if you have questions about it, or you have these slides that sort of let you know what's going on. But, you know, here's the summary. Center for Disease Control announced the issuance of an order under Section 3621 to halt residential evictions to prevent further spread of COVID-19. Their stated concern is if people are being evicted, then they're going to be out and potentially spreading this or exacerbating the pandemic. Well, you know, whether you believe that or not, it's irrelevant. It is the basis for this order. And of course, it's effective September 4 through December 31, 2020. So there are a bunch of differences between the CDC order and 4213. 4213 is an eviction prohibition, which 4213 had some attributes too, but it dealt with rent that accrued during a certain periods of time. The order is certainly not as sophisticated, for lack of a better word, as 4213. It's more just sort of a blanket period of time where you can't evict for non-payment of rent. Is it constitutional? Well, first off, it applies, even though Oregon has its own COVID-19 tenant protection statute. The order says that states, cities, municipalities can legislate this, but they have to provide the same or greater level of public health protection. So, if you have a statute that mimics this, like for example, if our statute allowed or went through the end of December, one could make the argument that, well, it's 4213 would govern, but since 4213 ends in 8 days or 9 days, whatever it may be, then I think that a tenant could say, well, that doesn't apply. In fact, the statute ends, and so it doesn't provide the same level of public health protection. There are lawsuits that have been filed, and I'm sure there will be a zillion lawsuits filed attacking the constitutionality of this. It is a bit disturbing, just from a personal point of view, that a federal agency can, with sort of a stroke of a pen, effectively, put a lot of landlords in a pinch. Interference with contract is one, but and the connection between COVID, public health, public safety, public health protection, and allowing tenants not to pay rent. I'm not saying there's no connection. It's it's not like a mask mandate or something like that. But any event, that's my soapbox a bit. I have some concerns about it. I'm sure a lot of landlords do, and a lot of landlords are filing suit. And I suspect that Oregon, it might be the same thing. But the challenge here with these lawsuits is that they they take a long time, and this thing's going to end at the end of the year. So so who is covered? Covered persons are covered, and that's any tenant, lessee, or resident of property leased for residential purposes who, one, signs and delivers a sworn declaration attesting to certain facts. So difference here, as opposed to 4213, is that tenant needs to do something to benefit from it. They need to provide this declaration. It does not apply to commercial tenants. So you're on your own there. So what is prohibited during this time period? Bans all evictions of covered persons for inability to pay rent during the order effective period. So during that period, you can't evict them, just like 4213. Does not distinguish between rent incurred before September 1. So it should be September 4, actually. So if there's rent that's accrued before, you can't kick them out. So in this situation, if this order applies in Oregon, you can't evict them even if they don't pay October rent. So you have these dueling statutes. You have 4213, which says, well, you don't have protection under here, but then you have protection under the CDC order if you provide the declaration. So it's going to be complicated, and I'm not entirely certain how that's going to work out. But I think that the tenants will be able to argue that, well, hey, you can't evict me during this period. So what is not prohibited? Charging or collecting fees, penalties, or interest for failure to pay rent on a timely basis. This is different than 4213. Said no fees, no late charge, whatever. You can charge those during this period. So if they're not paying, you accrue whatever late charges you have on it, or interest. It expressly excludes evictions based on, and this is very similar to 4213, although not laid out as in detail, that you can evict them for other things: criminal activity, threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to property. Number two, threatening the health or safety of others. If the tenant has COVID-19 and they're taking reasonable precautions, then you're just asking for trouble if you try to evict them. For violating any applicable building code, health ordinance, or similar regulation relating to health. or violating any other lease obligation other than timely payment of rent. So again, if you're going to do this, remember, if you're going to base an eviction to say, hey, well, CDC doesn't apply because you violated something here, you still need to comply with the Landlord-Tenant Act, okay? The CDC doesn't give you sort of a way to sort of go through that. You still have to comply with it. So it's like another layering of statute on this. So what must the tenant do? Again, the tenant must sign a sworn declaration. Declaration must be delivered to the landowner, owner, or the residential property, or other persons who have a right to evict. Property manager, probably fine. And each adult listed on a lease or rental agreement must provide the declaration. So if you have multiple tenants, multiple adults in there, you want one, you need one from each one of them. So what are the declarations? What do they have to stay? It has to use their best efforts to obtain all available government assistance for rent. There is an income limitation. So people making more than $99,000 a year cannot legitimately avail themselves of the CDC order. That you can't pay the full rent or market or make a full housing payment due to the substantial loss of housing income. Again, attesting to the impact of COVID, you're making your best efforts to make partial payments. And then if you're evicted, you'd essentially be homeless or go to a shelter. So these are the things that the declaration must contain. The CDC was kind enough to put in the order, or put in the order itself at the end, a sample declaration here that you can use. So you don't have to, there's no requirement that you inform the tenant of this right, unlike 4213, which says you got to tell the tenants all their rights. I mean, this is out there, and if the tenants want to avail themselves, they can. If they don't, they don't. So what happens if they fail to provide the declaration, right? I mean, you can't proceed with an eviction. What happens if the tenant provides a declaration, after you've terminated the lease, maybe you filed an FED? That's a good question. I don't know. I suspect that, they could provide it late, very late, and you can't evict them. So, even if say you get a judgment restitution, maybe they say, oh, by the way, I need this. I can't make my rent payments because of yada yada. They provide a declaration. I suspect that might be enough. Who knows? It's unclear from the order. So what are the landlord penalties? Yeah, it's jail time and money. If you're an individual, up to $100,000, or up to $250,000 if it results in death. I don't really know how it would result in death. Maybe if you kick someone out and they died on the street, or I don't know if they got COVID. I mean, I guess they could try to make that connection. If you're an organization, $200,000 per event, or $500,000 per event violates if the violation results in death. So there are real consequences here to a landlord violating the statute. So be very careful. It's going to be really interesting to see how the CDC order plays out. So the last piece, and I know we're running out of time. I want to make sure we have time for questions. Is that House Bill 4204? This is the statute that allows certain borrowers to avoid or to defer making loan payments. The original emergency period was April 1 to September 30, but under the statute, the governor had the ability to extend, and she did in fact extend it to the end of December. Unless that bill is amended or whatever, then the emergency period under 4204 expires at the end of December. It applies to both residential and commercial borrowers. But the difference between residential and commercial is that resident is how you notify. You sort of have to trigger your entitlement under the statute. Residents have to merely attest to it, which is, could be a lot of things. A commercial borrower, so for example, if you have clients that have multiple properties and their tenants aren't paying, so they can't pay their loans, then you can request application of the payment deferrals. You have to provide financial statements to say, hey, my income is reduced because of COVID. You don't have to show or prove that you can't make the payment. You just have to show that your income's been reduced. You just provide financial documents, but that should be pretty easy if you have a simple P&L statement regarding a property or properties, and say, look, my tenant's not paying me. Here's my reduced income. I think that should be fine. Interestingly, the missed payments are added to the end of the loan. So it's not like this 6-month grace period. You basically take the missed payments and you tack it onto the end of the loan. So if you have a 20 or 30-year mortgage, I mean, that's, that adds to the end. And there's a big debate now about how, how's the interest component applied? Is the payment term extended? I think what's going to happen is there's a balloon at the end of your period of the missed payments. And there's no foreclosures during the emergency period at all, unless your notice of default was sent out, recorded before the emergency period, or you have judicial foreclosure judgment before the emergency period. So there are some exceptions to that, but we're so deep into this thing that, if you're dealing with it now, no lenders can foreclose now on you until the end of the year. So that's my presentation. Again, my information's here. If you want these slide deck, I'm happy to send them to you. And I think we can open it up to questions here. Chrissy, if you want to do that. You got to turn your mic on.
Thanks, Craig. Okay, the first question. We had a client buy a property to do a tear down and build. Are we able to serve a 90-day notice on October 1st to the existing tenants to vacate due to the planned demolition?
Yes, I think that you are, well, they bought a property to tear down and build. Yes, I think that if you on October 1, you don't have the emergency period, you can then do you can do the cause eviction, no cause really eviction. If they've been over the 12 months, yes, you can send them notice at that point, 90 days. And you may have to provide a relocation benefits under the statute.
1 month's rent, correct, okay. Okay, perfect. What are my options if my tenant cannot repay their balance within the grace period?
Your options are no different than if a tenant can't pay rent now, or not now, but prior to this. You can work with the tenant, or you can send the tenant a notice to pay or quit. So it's unpaid rent that becomes formally, like officially due after the end of the grace period. Or you can work with a tenant to, figure out, pay it back over time, of course.
Okay. Okay, question number 3. During the emergency period, is the clock ticking towards the calendar of the 1 year of occupancy? No cause eviction goes into effect?
Yes, and it's actually extended too. So during that period of time, the clock, that counts towards their 12 months in.
Well, isn't there a 30-day extension?
Yeah, after a 30-day extension of that, yes. Okay. So yeah, it applies. So if someone would have, if they're 12 months, well, you couldn't, like if they were only 11 months at the end of the emergency period, the statute's giving them another 30 days. So they're pushing that out, making it harder for landlords to no cause a tenant.
Okay. So if my tenant defaults on their October rent, can I evict them, or what's the impact of the CDC order?
Under 4213, you can evict them, but under the CDC order, you can't evict them. So if you say, give them a 72-hour notice to pay rent or quit, and they do nothing, and you can evict them because they have to trigger the application of the statute. Unlike 4213, which is automatic, the CDC order is not automatic. A tenant has to do something about it. So if the tenant doesn't know it, and you go to your FED, then you're not violating the law.
Okay. Okay, I have a tenant that moved out during the emergency period. and they had unpaid balances during that time. Does the grace period for repayment apply? And then the second part of that question, can we report them to the credit agencies since they aren't a current tenant any longer?
Yeah, so I think that my view is that once they vacate, they're no longer a tenant, and the statute is intended to protect tenants. So if they leave, then I think the amounts they owe are owed because they're no longer a tenant of yours. So I think that you can pursue them after the emergency period. I don't think they get the 6 months grace period. I think that only applies if they're a tenant.
Okay. Okay, I think those were the main questions. I think what we're going to do is we may follow up after the meeting with an email and just include some frequently asked questions, because I know
Sure.
there'll probably be a few more questions that come up.
Okay.
Thank you, Craig.
Thank you very much.
Yeah, thank you, Craig. That was really valuable. I'm sure there was a lot of information. There's still, like Chrissy said, some questions that we'll address. Just wanted to remind you guys that this was recorded, so we'll be hosting it on our Facebook page and on our website, westerntitle.com. For those of you who are licensed brokers, you'll be getting your certificate for the 1 hour CE credit via email later this week. So thank you all for joining us.
Thank you.
Thanks again, Chrissy.
Bye.